Good day, sir. I am Loviri Zain, and this is my answer for this assignment. Customary international law is a source of international law derived from a general practice accepted as law. Such practice can be found in official accounts of military operations, but is also reflected in a variety of other official documents, such as military manuals, national legislation, and case law. Katie Johnston mentions that the International Court of Justice regularly invokes a two-element test for the identification of customary international law, mainly state practice, being accompanied by opinio juris. Yet, in its case law, the court's application of the test has appeared inconsistent as to whether it actually requires both elements to be fulfilled in order for a customary international law rule to be identified. In some cases, a lack of evidence of opinio juris on the part of states participating in a practice has been predictably fatal to the argument that a rule of customary international law exists. Yet, in other cases, there is still no clear evidence of opinio juris on the part of states participating in the practice, but the court nevertheless concludes that the legit customary rule exists. This characteristic sets practices required by law apart from practices followed as a matter of policy. States recognize that treaties and customary international law are sources of international law, and as such are binding. This is set forth, for example, in the Statute of the International Court of Justice. One illustration of the binding nature of customary international law is its application by national and international courts and tribunals. Besides that, Cristina Dauguerdas argues that international organizations, as such, can contribute directly to the creation of customary international law for three independent reasons. First, the state establishing an international organization may subjectively intend for the organization to be able to contribute to the creation of at least some kinds of customary international law. Second, the capacity may be an implied power of the organization. And third, that capacity may be a byproduct of other features of authorities of the international organization, specifically the combination of international legal personality and the capacity to operate on the international plane. On the other hand, another scholar, Jordan Poss, states the importance on noting Common Article 1 of the Conventions, which reflects customary law, requires that signatories and their nationals respect and ensure respect for the conventions in all circumstances. Thus, customary and treaty-based Geneva obligations is not merely to enemies, but also to all other signatories, and as customary to all humankind and without putative excuses based on legit necessity, reciprocity, or reprisals. Customary international law also provides relevant rights for all participants in international or non-international armed conflicts, whether or not they are nationals of a state, nation, or belligerent that has ratified a treaty reflecting the same rights. With respect to treaty-based rights, it is worth emphasizing that the nationals of a state that has ratified the 1949 Geneva Conventions are bound by and have numerous express and implied rights under such treaties. Moreover, William Dodge recognizes the important role of customary international law in regulating the exercise of jurisdiction by states. It recognizes that jurisdiction to enforce is strictly territorial and may not be exercised in the territory of another state without the other state's consent. He also recognizes that jurisdiction to prescribe requires a genuine connection with the regulating state, and that jurisdiction to adjudicate is subject to customary international law, rules of immunity, though for most part it does not attempt to restate those rules. Catherine Fortin notes on customary international law affects a diversity of duty bearers and its role in the unity of the system of international law. It has been conversely said that customary international law is of primary importance to the unity of international law. Due to the manner in which it is developed, there are rarely conflicts between different customary norms. Secondly, general customary international law is widely accepted to be of general application, valid for all states. In other words, all states have identical obligations under customary international law. Lastly, according to A. Roberts' interpretation, international law is a system that is designed inter alia to combat the de facto diversity of its subjects and provide a means of regulating equal states. Indeed, the legal fiction that all states are free and equal hides the fact that states are often very different in political, geographical, ideological, religious, and military terms. The uniform application of customary law between states is a key means of allowing common interests to prevail over diversity. In that sense, general customary international law is an important legal glue that joins and unifies the international community of states. To conclude my answer, customary international law is a source of international law which undergoes two elements test to be identified. Although for case law it may be inconsistent, the court still concludes that customary rule exists. The creation of customary international law is a combination of international legal personality and the capacity to operate on the international plane. Article 1 of the conventions reflect customary law and also provides relevant rights for all participants in international or non-international armed conflict. It is also recognized the important role of customary international law is jurisdiction to enforce is strictly territorial and it requires a genuine connection with the regulating state. Customary international law affects a diversity of duty bearers and is of primary importance to the unity of international law. Thus, is widely accepted to be of general application, valid for all states. And lastly, international law is a system designed to combat the diversity of its subject and provide a means of regulating equal states, making it an important legal glue that joins and unifies the international community of states. That is all from me, sir. Have a nice day and thank you.